Good evening, everybody. Welcome back to the channel. So glad you are here, and I am grateful that we had some news today. We're going to dig right in. We're talking about the case against Karen Reed, 42-year-old, who was put on trial, as we all know, for the murder of her boyfriend, Boston PD officer John O'Keefe, and that ended in a mistrial, as we all know. Her attorneys, Mr. Alan Jackson, Mr. David Yannetti, have filed a motion just today that is a motion to dismiss. And so I thought we would get together. I have not read the motion yet. It's 16 pages. But as you know on this channel, I love docs. I love getting into stuff like this. So we are going to read it together. Hey, real quick before we do, Molly, who's been around on the channel for a long time, says my notification bell isn't working, keeps turning off. That is a great opportunity, guys, to talk about the fish tank. If you go to my website and click on this little fish up here, go to the fish tank. This is a group of us who hang out together on Facebook. And one of the things that my moderators / admins do is you can sign up for a Facebook notification. They will send that your way. So please, 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 if you have not done it yet, go over to the fish tank on Facebook and join up. And that way notifications will work better. And Molly, I'm sorry that YouTube is falling down on that for you. Okay. Another quick thing, as Autumn, because she's on top of things, if you want me to see a particular comment, I do have a filter on. Just put GF in the comment and I will see that comment, and that helps me to kind of go through and share some of those comments with you guys. So I will just put this up for a little while for you guys to be reminded of that. Okay, let's head over to the document itself, shall we? Haven't read it yet. I have not read it, and I'm looking forward to. Let's do this together. Here we go. Defendant Karen Reed's motion to dismiss. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3, currently pending against her, on the grounds that the jury reached a unanimous decision to acquit her on those charges. Alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. That, to me, is a novel argument. Hey, listen, we've talked to the jurors, and they came to a unanimous decision. So even though they didn't come to a unanimous decision on everything, because they did on these 2 counts, we should just go ahead and dismiss. I've never seen an argument like this before. It's pretty novel. Okay, continuing on, because they can't just say, here's my motion. They have to talk for a long, long time. Here we go. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretend offenses and arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect of our criminal justice system. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. This is from the Fifth Amendment. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. I guess the quibble with this is that there has not been a verdict, right? There was not a verdict. Now, I'm sorry, guys, I'm a layperson. I don't know about this. But this seems kind of a wobbly motion, but let's keep going. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors indicating in no uncertain terms that the jury had a firm 12-0 agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice systems for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court they could not reach a verdict on the 3rd charge alone. So that's actually pretty good. That's pretty good strategy. They're like, hey, we want a motion to dismiss, but if the court isn't quite ready for that, we would like the court to allow us and give us the power to find out if this unanimous quote-unquote verdict did take place on 2 of the 3 charges. Interesting. Okay, background. On June 9, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of Massachusetts law, vehicular manslaughter in violation of that law, and leaving the scene of personal injury or death in violation of that law. A jury trial began on April 16th. On June 25th, 2024, the jury began deliberations. On July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. See the affidavit. There are a couple affidavits that we're going to read here. Okay. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing an opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter. Call this person Juror A, who stated that he or she wished to inform him of the true results of the jury's deliberation. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. Another day later, July 3rd, Attorney Yannetti was contacted by 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. David R. Yannetti affidavit. Okay. Informant B sent Attorney Yannetti a screenshot he or she had received from someone. of text messages that that person, intermediary B, had received from juror B. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Okay. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. Informant C sent attorney Inetti the below screenshots of his or her text messages with intermediary C regarding what juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock. 4 no, 8 yes. Informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. Intermediary C, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. All right, so that's the background. The argument. The second count, Donna, was manslaughter. First count, murder 2. Second count, manslaughter. Or let's see. The 3 counts were murder 2, manslaughter, leaving the scene of an accident with injury or death. I think I got that right. Okay. The jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. I don't know that it does, but let's read their argument. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. Here, the attached affidavits by attorneys Jackson and Iannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. See the affidavits. Okay? Blah, 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 blah. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo, contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Oh, okay. That's interesting. Massachusetts state law in Commonwealth v. Tinsley, unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. It doesn't seem like a strong argument, does it? Maria asked, Gavin, is this coming from the defense or the prosecution? This is coming from the defense. This is coming from attorneys Alan Jackson and David Iannetti on behalf of their client, Karen Reed. Okay. B, reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. As I recall, the defense, when the jury first came back and said we can't come to a verdict, their argument in court was, well, I guess that's a mistrial then. And the prosecution was like, no, let's give them more time. It seems like what's happening here is that, they were happy for the mistrial, so they didn't argue that they should continue to deliberate. But afterwards, they found out new information and were like, hey, wait a minute. No, we don't want that mistrial anymore. That's what it seems like to me. Okay. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of defendant whose initial trial ends without a conviction. Is that true? This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorable disposed to her fate. I know if it ends in a mistrial, that's a weak argument. Okay, accordingly, heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given the full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives of a mistrial. So is it possible that Judge Cannoni here jumped the gun and declared the mistrial without the option of being heard, or without the opportunity given to the defense and the prosecution from being heard? That's what the argument seems to be like. But I honestly think that if she gave the defense an opportunity to be heard here, they would have been, you know what, mistrial. I think you're right, Judge. I think they would have said that. Okay. Here the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Blah, 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 blah. Whole bunch of, yeah. Okay. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. The Supreme Judicial Court's holding in Commonwealth v. Roth, the courts should not request partial verdicts on lesser included offenses charged in a single count, does not pertain here. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Okay, such inquiry in effect implies that the jury should consider conviction on the lesser count. No similar danger is present here, as here the jury was asked to return 3 separate verdicts on 3 separate counts. Okay, in this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward, and the defense contends constitutionally required, follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court, this is the state's court, has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict should be returned as to one of the counts despite deadlock on the other counts. Interesting. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate communications with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should the court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or an evidentiary hearing to substantiate the existence of an acquittal. A voir dire, it pains me to pronounce it that way, but is basically a one-on-one question, right? Question each individual juror individually. Okay, should the court seek the affidavit of each juror, i.e. jurors A, B, and C above, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. You know, the thing that occurs to me here is it feels like they're going to lose this. They're going to lose this motion. I mean, I would be shocked if they won this motion. But it does give them grounds for appeal after, say, Karen Reed were retried and found guilty. This part of their defense would give them grounds for appeal. So maybe it feels like to me that they're like, they may know that they're going to lose this, but they want to be on the record so that they can appeal later. Okay, conclusion. For the foregoing reasons, Ms. Reed respectfully requests this honorable court issue an order dismissing counts 1 and 3. Did I miss? I think I missed something here. Yeah. Just as the court in McCallop approved questions to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of the jury trial and to the protections of the double jeopardy clause and its related state judicial protections. And then the conclusion. Okay. Let's go to the affidavit. This first is the affidavit of David Yannetti. Now remember, Mr. Yannetti is a Boston lawyer. He is considered a very good lawyer. And then Mr. Jackson is kind of a high profile, what would we call it, celebrity attorney from California. So we're first going to read from Mr. Yannetti's affidavit. Okay, I, David R. Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. 1, I'm an attorney licensed in Massachusetts, and I represented Karen Reed. Okay, number 2, on July 3rd, I received communications from 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. Number 4, on July 3rd, Informant B sent me a screenshot he had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B. In the screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back With that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. That sick means that they left in like the mistaken grammar. They gave us free counseling forms when we left. Okay. Number 5, based on the first name of juror B given to me by informant B, I believe I am able to positively identify which juror he, she was and confirm that he or she was a deliberating juror. Number 6, on July 3rd, informant C contacted me to say that he or she personally knows juror C as they used to work together. Informant C and juror C also have a mutual friend, hereinafter intermediary C, who is a current coworker and friend of juror C. Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday, the 1st of July. He or she told me that he or she believes that post led intermediary C to text him or her and inform him or her that juror C was a deliberating juror on the case. Informant C told me that he or she thereafter reached out to juror C via text message and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was, and that juror C was relieved that it was finally over. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, informant C sent me 3 screenshots of a text message exchange he or she had with intermediary C. Informant C told me that intermediary C was reporting to him or her during this exchange what juror C had revealed during the Zoom meeting. The text message exchange reads as follows. Intermediary C, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4, no, 8, yes. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, he or she voted no because the cause of death was twofold of hypothermia and head injury, of which he or she was convicted that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end. He or she's not sure what he or she's going to do. He or she's going to lay low for a couple days and see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. Wow. Okay, informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C says, she should have been acquitted, I agree. Yes, the remaining charges were that they were hung on. And that instruction paper was very confusing. Informant, what a great experience for him or her. Amazing that they let the Alberta in the last day. Don't know what that means. Intermediary, he, she felt very honored to be part of it. He, she was redacted physical description of juror C. Everyone else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Informant C, that's the way it should be. I knew it was an intelligent jury. They will be studying this case in law programs for years to come. I'm on how to investigate and try a case, I guess. If they all agree on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is retried on that charge. Okay. Based on the description of juror C given to me by informant C and confirmed by the redacted content of the above text message, I'm able to positively identify which juror she or he was and confirm that he or she was a deliberating juror. Okay, that is Mr. Yannetti. Here's Mr. Jackson. All right. I, Alan Jackson, declare that I am this amazing lawyer. On Tuesday, July 2nd, 2024, I was contacted by juror A, true name and identity. Wow, guys, I've been reading too much here. I'm stumbling over my tongue. Identity withheld to remain anonymity. To maintain on it. Holy cow, Gavin, I'm having issues here. Okay, on Tuesday, July 2nd, I was contacted by juror A. Based on my conversation with juror A and that juror's description of who he or she is, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire, whatever process, I was able to positively identify which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it important to disclose such results because he or she believes that those results significantly impact Ms. Reed's rights. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table and that all 12 jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following the determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. I wonder how they get caught on manslaughter then. Okay. On July 1, 2024, when the jury presented a note to the court, all counsel were ordered into the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was in an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and count 3. Ms. Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief. Blah, 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 blah. Dated July 3rd. All right. That's the whole doc, guys. Unfortunately, in all this, the thing that gets lost is that this guy lost his life, right? But, and by this guy, I don't mean to be flippant or disrespectful, is Officer O'Keefe. Let's see what you guys are talking about in the comments here real quick. Coming on down. Got a lot of highs and hellos. Wow, a lot of you guys talking. Molly Clean says, there was a change made to the verdict form after the jury began deliberations regarding a not guilty option on the form. The judge was a bit snacky, I'd say. She was snacky about the defense bringing this up. Remember? Yeah. Oh, yes. I remember that very well. Very well. Teddy the Bear, I feel like it either wasn't explained correctly to the jury or the jury didn't explain it correctly in their letter to the judge. Yeah, possibly. Autumn says, I don't understand a lot of this. And I watch crime stuff every day. It's confusing sometimes. Yeah. I was confused in the motion that they kind of went back and forth between things that seem to apply to the case and seem not to apply to the case. I mean, obviously, these two guys are high power, charge a lot of money kinds of attorneys. They know better than we do, I'm sure, but I'm definitely confused by it too, Autumn. Let's see what else. Molly, and when the verdict form, not verdict, I was 100% confused. It was about as clear as mud. You know, one of the things that is frustrating for jurors is that the instructions seem only clear to the instructions a judge give jurors seem only clear to lawyers. They don't seem clear to regular people. And I mean, I guess I understand now that there are included lesser charges, but they were indicted 3 separate times. So I guess that means there are 3 separate charges, not like in the Commonwealth of Pennsylvania. The way it would be is like, here's the main charge. If you let's see, guilty or not guilty. If you check guilty, then move on to the next. If you check not guilty, then move on to the next one. And then on the next one, if you check not guilty, move on to the next one, right? I've seen that happen in court, but that didn't seem to be the case here. So it was confusing to me for sure. Let's see. Yes, unanimous means that everybody's in agreement. Correct. Donna says, I think should have been a mistrial on second day when defense wasn't shown the jury instructions first. They were pretty upset about it for sure. Brian Albert was the enforcer for the Commonwealth on closing arguments. Okay. Let's see. Patty here from Chicago. Good to see you. I think that's about all. And that's a good place to end this. We don't need to belabor this. We've been going at it for 36 minutes. But before we go, guys, let me just give you a quick reminder that you can always check in with me on my website, gavinfish.com. There's always a link down below. Click on the little fishy up there in the corner, this little guy right there. That'll take you over to the fish tank. We have a lot of fun over there. And if you're not getting YouTube notifications, please do sign up for the notification chat inside the fish tank so that you never miss when I live stream. All right, guys. Hey, just so you know, this week and next week, I am going to be on vacation. It's headed out to the West Coast to spend some time with my wife's family to celebrate her parents' 50th wedding anniversary that is happening this year. We're all gathering in the summer right on the coast to do some things that we love to do. So I will be there in California. I'll probably check in from time to time. And then, of course, we're going to head north from there, go back up to Sacramento and visit my folks before we head back over to Pennsylvania. We're going to do this all by car, and we're going to see some states that we've never been to. So probably hang out in Petrified Forest National Park, see a couple things we haven't seen before as a family. So we're excited about that. With that, guys, I will bid you adieu. Thank you very much for joining me today, and I will see you on the next one. Take care. Bye-bye. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.